Good. Excuse me. It's not a great way to start. And okay, so the thing was showing that it wasn't live. If I'm live, please somebody comment in the comments that you can see me, because it's showing an error, which is interesting. But so please post a comment if I'm live. Looks like I am live. So I am live, even though nobody. Yes, thank you very much. What a great way to start. Everybody, good morning. I think unless you're in Europe, it is good morning. So good morning to everybody. Not legal advice. Please like, subscribe, share, comment, whatever. Appreciate you all being here this morning. Was going to talk a little bit about gtii and Alpine and bring you up to date about that. I'm going to be trying some different things in the future. I always talk about Alpine and GTI and keep you updated about that. But I'm going to try to broaden things out a little bit in the future. Not today, but in the future. And I may try a little different types of things to make it more interesting. I usually do jokes before, and I'm going to try it a little differently. I'm going to try to let those happen more organically as we go. I saw something though that caught my attention. It was an interesting comment. Some might find it a little bit sharp, but so I'm a Dodger fan here in California. The Dodgers won the World Series. I started following the Dodgers in 1966, by the way, when I was 72 years old. I think I was 1966. Believe this or not, I was 7 years old. Started to follow the Dodgers. Some very elderly immigrant in the United States suggested I listen to Vin Scully under my pillow, and I became a Dodger fan. Eventually, the Dodgers are big, obviously, in LA. They draw very well. But what's interesting is prior to 1981, the Hispanic community in Southern California, which is large, did not like the Dodgers. They didn't like the Dodgers because when the Dodgers moved to LA in 1958, they moved, and the Giants moved to San Francisco in 1958 also. By the way, the Giants had first pick. They chose San Francisco over LA, and in terms of economics, that was a pretty bad choice. Their owner also, when they went out to the place that they were going to decide where to put the ballpark, this is referring to San Francisco, they went out in the daytime, and apparently in the daytime it was great. It was Candlestick is where they went, Candlestick Point. But at night the wind would howl, but they never went there at night. They elected to build the stadium there, and it became like a joke because it was very difficult to play there. Anyway, then Fernando Valenzuela became a player for the Dodgers. He was a young Hispanic player. He was from Mexico. He was, I think, 18 when he came up. He was a phenom. And although the Hispanic community hated the Dodgers prior to that, because when they built Dodger Stadium, they evicted a bunch of people, poor, lower income people who were living in Chavez Ravine, promised them, I think, housing, never provided it. And so it was a big to-do until Fernando came in 1981, and the Hispanic community are huge now Dodger supporters. They also celebrate victories very vigorously and use fireworks. So the comment, wow, this is a long way to get in the stupid comment. The comment that I saw that struck me was because there was somebody who was setting off fireworks and had a little bit of a mishap, let's say, to the least. And he suffered an injury. So the comment I saw that I thought was funny was, let's clap for the guy who blew off his hand with fireworks. That's the comment I saw that, whatever, because there was somebody who literally lit off fireworks, and that was the deal. So that was really funny, I'm sure. So big Dodger fan, very happy week. Before I get to GTII, I don't know if you guys know this or not, but there's an election coming. That is on Tuesday. We will see the outcome. I voted, just saw, I'm going to be upfront and out there. I voted for neither candidate. I like neither of the candidates. That's who I voted for, and I'm in California, just to let you know. So I'm not a big fan of either, but I'm interested in the election and the outcome. It should be really interesting. I hope for the best, whoever wins. So I'm not fatalistic in that respect. I'm hoping that whoever wins, um, things work out. That's my hope, and my bigger hope is that in 4 years, that the choices we have for the election are better choices. So that's kind of my bigger goal. So that's the election. I'll be following that. Maybe I'll do a live stream about the election as it's ongoing. I follow the polls every day. You know, polls are obviously, it's subject to whatever the question is and the slant. They all ask slanted questions, even if they're not trying to. It's not possible, because when you when you're asking a question, you're putting your own personality and decision making into it. So I think it's all slanted in some way or in the other. It's close, and it depends if it runs like prior elections. So the way I look at it is, if the polls are consistent with prior elections, then uh, it's more likely that Trump will win, because I think he will outperform the polls. Because this election cycle was wild because Biden got out, and so the polls are not like normal, then that would be a different thing. So we'll have to see what that is. All right, I did that stuff. Now let's go to gtii. So there's 2 actions pending. I'm going to summarize. 2 actions pending. Still 2 actions pending. There's one in Nevada. There's one in California. The one in Nevada, to the extent you guys are out there or are plaintiffs in that action, that is ongoing. And I'm going to kind of bring you up to speed as to where that is. And then there's the action in California, and I think I referenced yesterday that, and I joked, in honor of the Dodgers winning the World Series, Rabari and Reichman dismissed their action against me. We're now cleaning up the final dismissal, and that action will be dismissed at some point in time, and I'll talk to you about that. First of all, I want to talk about Alpine. So I still follow Alpine, and just to kind of bring everybody up to speed. And again, this is all opinion. And let me address that too, since I've had personal experience. So I've handled defamation cases to trial, and I have now been sued for defamation. So everybody out there, not legal advice, of course, but kind of like talking about it. So when you are in a public forum and you say this is opinion, does that protect you? No, it doesn't protect you 100%. What happens is, in determining if it's defamation, you're looking to see if someone is stating facts or if they're stating opinion. And sometimes that can be hard to distinguish. So when somebody says they are stating an opinion, but that opinion is based on some underlying set of facts, that could still be defamation, because defamation is a false statement of fact that's not privileged, that causes harm. So it has to be a fact, first of all. And what is a fact? A fact is usually, or the courts use kind of a test. A fact is something that you could prove yes or no. So, for example, if you said I was wearing a blue sweatshirt, we could prove that it's not blue because it's red. But if I used an adjective like, that is an interesting color, that's not something that's provable as yes or no. So sometimes it's difficult for the determination of whether something's fact or opinion. And that's often a dispute. And in my case, it was also a dispute. So if you're in a public setting and you're on Spaces, or you're doing a video, or you're appearing on video, most likely you could say whatever you want, nothing's going to happen. However, if somebody takes offense or has some ulterior motive, they might pursue you. So you have to be careful whatever you say in public, make sure that you don't make accusations against people unless you feel very confident about that, because you can make accusations that are true and somebody could still sue you. Because in America, the great thing about America it is, and in California and all the big states, is anybody can sue anybody for anything at any time. So that means that even if you're in the right, you can get sued. And for most people, if you get sued, it's a disaster, because you could prevail, and in other words, you could win, but still have to pay a bunch of uh, money in legal fees, and that could be a disaster for everybody. So I'm not trying to discourage people from being uh, saying with their piece wherever they want to say their piece. I'm just saying that there is risk when you're public. And again, I was in a particular position where I must have been annoying somebody enough, and they were trying to. And it was earlier in the case. There may have been some strategy, and I was trying to think about that. There may have been a strategy behind suing me, besides just trying to shut me up. But the case was it was much earlier on, so we knew much less about what was going on. So maybe they were trying to prevent the disclosure of information. I don't know. I don't really know the strategy. I didn't think it was. I thought it was probably an expenditure of money that probably was unnecessary. My opinion. And I know that, well, my impression is that money for the lawyers became an issue because when the lawyers, and they never made it out of the case, as it turned out, but when the lawyers in my case in California, in which I was sued by GTII in some fashion, Reichman and Rabari, when the lawyers made their motion to withdraw, and they indicated that the relationship between the client and them had broken down, because you can't really describe what the problem is specifically. So when you're an attorney and you're trying to get out of a case, you can generally describe what the problem is, but you don't want to negatively impact your client. So if your client's being a dick, you can't say that. So you have to kind of use words to the effect that the relationship is broken down and whatever. And so the most likely reason why the relationship breaks down and why a lawyer would stop is if your client stops paying you. So that's a breach of the retainer agreement, and that would be a reason most lawyers stop. So it's likely, since it was in the motion, it's likely that they were having a problem, or somebody wasn't getting paid, or somebody decided not to pay somebody. So I don't know who or what, and it's just my speculation, but based on my experience and past history, somebody wasn't getting paid. Um, and somebody moved on. Now, shifting, and I'm going to kind of bounce around a little bit, shifting to the Nevada action, one of the acts that the receiver discovered. So there's a receiver in Nevada action. So that was appointed, I think, in August, September. He's produced one report. In the report, and I think I talked about the report at one point in time. In the report, he talked about the fact that they were going after assets, and one of the things they've had found, apparently, because I think the money already was returned, was that $300,000 of GTI money had been sent to an attorney in New York for possible use. And then there was a second attorney who got a $10,000 retainer, and I believe that was requested to return. Both those sums, as far as I know, were returned. So I think it's like 300,000 approximately that was returned. The attorneys, as far as I know, both cooperated and provided their money. What's interesting to me is the one attorney in New York, he spoke to me. So in, I don't know, February, March, when I first got involved in actively being involved with GTII, I was little annoyed and was obviously suggesting that unless somebody did something, that I was contemplating pursuing legal action. So some attorney out of New York contacted me, who also was a shareholder. It wasn't really a legal discussion because I wasn't involved in legal at that point in time, but we had a conversation, and he told me about he was a shareholder in gtii. I think he told me he had, at least at that point in time, he had about 800,000 shares. Remember, we had a conversation. He talked to me about what he knew, because he was based in New York. He apparently knew the principals, the officers, etc. Didn't have, as my recollection, didn't have like great things to say, but he was more interested in me not going forward with legal action. They were working on something or whatever. Obviously, that didn't turn out to be fruition. That never happened. But that attorney was the one who later, and that was probably July, August, could have been September, he's the one who got the $300,000. Now, he was asked, and again, I wasn't involved in this process because this is once the receiver is in place, but the receiver's counsel, so the receiver is a person who's managing the company at this point in time, but the receiver has counsel also. So they have an attorney that represents the receiver day to day, and there's also corporate counsel, and the corporate counsel is there to try to get cleansed and clarified all the deficiencies that exist with regard to GTII, get it back audited properly, get it trading properly, etc. So there's two sets of counsel. But it's interesting to me that this attorney in New York who had contacted me before, who had discussions, and I had discussed this with other people, that there was a moment in time where he was going to substitute in the current matters. I don't know if it was the Nevada action or the California action. And if he did that, I was going to move to disqualify him, because I had a substantive conversation with him about this matter where I thought he wasn't particularly let's say I don't think he was very nice necessarily about the principals, the officers and directors. And I was going to ask him about that. And if he's giving a critique and then he's representing them, that creates a potential conflict of interest, because I could call him as a witness, and an attorney can't be a witness and counsel at the same time, because it's a conflict. Why is that a conflict? Because let's say you're an attorney, I'm representing you, and I want to be a witness for you. Once I go on the witness stand, then my credibility is put into question. And when my credibility is put into question, when I go back to the lawyer chair, especially if it's a jury, my credibility as a witness might impact my credibility as a lawyer. So therefore, general rule, can't be a witness and a lawyer in the same case. So if this New York lawyer got $300,000, who returned it, my understanding is, was going to be the lawyer, I was going to move to disqualify him. We never got to that point in time, because he, at least as of now, is not counsel. So my action, now I'm going back to my action. This is California. This is GTI, Reichman, Rabari versus me. We had a bunch of hearings about 3 weeks ago. No ruling, but no, 2 weeks ago, no ruling. So I filed a motion to dismiss. And unlike the general securities lawsuits, so we hear, if you've been involved in other tickers, you hear about securities lawsuits, class actions, and those fraud claims. Those pleading requirements, pleading is what you file, like a complaint, that's a pleading. The requirements for those are much harder for a plaintiff than in a general matter like this. And even though like a defamation action, for example, are difficult to win for a plaintiff, because there's a lot of issues. In terms of pleading and surviving like the initial stages, is much easier to do than in like in a straight securities lawsuit, which is not this. So I filed a motion to dismiss, basically for on a bunch of reasons. Some of it because it's. I hope this is not too complicated, but there's a bunch of defenses you can have to a defamation claim. Some of those defenses are if something's true, if something's privileged. Now, at the early stages of the case, you're only allowed to assert certain defenses at that time because you have to accept as true the complaint at that point. So I asserted a bunch of defenses you could related to defamation, and that didn't make a difference what the complaint said, that they couldn't win. So we had a hearing on that, and there was also an anti-SLAPP statute. What's an anti-SLAPP statute? A lot of states, including California, they protect speech, free speech. So if somebody pursues an action against you based upon your speech, there's a procedure you can invoke at the beginning of a case to try to get rid of those cases, because what happens is you have to show it's protected speech. For example, a public forum like this about an issue of common interest, that would qualify. And then once you establish that, the burden shifts to the other side. So in this case, I'm the defendant. So the burden now shifts to the plaintiff, and the plaintiff, which would have been theoretically GTII, Reichman, and Rabari, would have to show a likelihood of succeeding on the merits. Now, it's different. We've heard and we've been involved with injunctions. And when an injunction happens, you have to establish the likelihood that you're going to prevail on the merits. But you got to do a pretty substantial showing. So that's on an injunction. Here, we're talking about an anti-SLAPP motion, again, protecting free speech. And the burden on the plaintiff, the party against whom the motion is being filed, is much lower in terms of succeeding on the merits than the injunction, where you have to show you have to prevail. So all you have to do is show a minimal chances that you are going to succeed. Now, I don't think in my matter that they did either way, but the judge could very well let the case go on a little bit to give them the chance to clean up their pleadings, etc. And we never got really to that point in time. Yesterday, and it's annoying to be honest. It was annoying because it takes time, and I'd rather spend it elsewhere. But it eventually, yesterday, the two plaintiffs, Rabari and Reichman, dismissed, and GTII was dismissing anyway. We've just been in process about that, and it's going to happen. We've advised the court, so that matter will be done, which will make me happy that that matter will be done. Again, I think it was my own opinion. I think it was a poor choice of expenditure of resources. I've told counsel for the receiver I think that they should pursue recoupment of those attorney's fees that were spent, because I think it was a complete waste of money on behalf of GTII and its shareholders. And any money spent on the action against me, I think was done, just my opinion, I don't think it benefited GTII or shareholders. I think it was just a waste of money. And so that's my view. So I've already suggested that they pursue the collection of that along with everything else. So that case is done, or will be done, and it'll free me from that case. Before I go to the Nevada case, I wanted to talk about Alpine really briefly. So I follow Alpine. Alpine, for those of you out there, is a prime broker that was involved, at least as to GTII, perhaps others. They've faced a lot of issues with the SEC, FINRA, etc. They've been disciplined numerous times. They had the one that always strikes me. I was thinking. So the two things that stood out to me, as we went through GTII, the things that struck out to me was with GTII when we got to the masseuse and the mechanic. I thought that topic was crazy. And with Alpine, what struck me with that, besides all the problems they had over their time, was that they, at one point in time, they tried to make their front man dealing with the regulators admitted, convicted sex offender. And it was amazing to me. You had a company, and by the way, the SEC and FINRA, they acted against them, but never did anything to really terminate their business. And I can't imagine in any industry some company being disciplined so much and being able to conduct their business. It doesn't make any sense, but that's the way it was. So a convicted sex offender running Alpine at some point, that's what they wanted, or at least to be the front man for Alpine, I should say. I forgot the guy's name, and he wasn't. There was some proceeding, and the SEC, I think, turned him down. I think that was the end, and he was admitted. So this wasn't in dispute. He was found, I think it was like in a movie theater, and he groped some underage girl, and his father was literally. They're in a movie theater. He's groping this girl. The father of the girl is next to his daughter. He's spotted. The guy runs out, and that's it. He admits to it. And usually when people commit, a lot of times when people commit misconduct, it's not the first time. So somebody who does that in a public place, that's somebody who probably needs a lot of help, and it may not be able to be helped. But anyway, that's Alpine. So these guys are functioning at some level, and but they're still ongoing. And as you know, there's two proceedings that are ongoing about Alpine. One, there's a proceeding in Utah. That's where the NSCC, etc., was trying to basically not provide services for Alpine anymore. There was a credit issue. They had to post like a $10 million to protect everyone. There was a problem. They were basically found to have been not in compliance. Their ability to trade was revoked. They got a stay, and that was probably 6 months ago, I'm saying maybe 5 months ago. They got a stay, and that still is ongoing. And unfortunately, in that system is, if the result goes against them, they still have an appeal. And the way those guys go, because to the extent they're making money, and I don't know what they're doing. I have no idea what Alpine does. I have no idea what Alpine is doing now. I have no idea if someone is using Alpine for purposes. I don't know if they're using some other entity for purposes. But it exists, and somebody's spending a boatload of money in legal fees, so there must be some reason why they're still hanging out, or else they wouldn't be spending the money on legal fees. Alternative is maybe why would somebody spend money on legal fees? One, they may have a positive outcome they're trying to seek, or two, maybe they want to stop somebody from seeing into what they're doing. Because maybe if you object and you block, maybe somebody doesn't see it. I've always thought that about GTI, by the way. I was wondering why perhaps people didn't act in a different way. There are all kinds of reasons why people don't act. People do it for psychological reasons. People do it for other reasons. I thought maybe could somebody be trying to, is it possible? Is it possible? And I don't know, but is it possible that somebody might be trying to conceal something? That's something that occurred to me, and I still don't know, but I know that I've seen that, like in litigation, often people delay. because you never know what's going to happen. Maybe the case will resolve itself. Maybe you'll never get to the issue that they're addressing. Maybe you'll tire them out. Maybe they'll spend all their money. We don't know, but anyway, Alpine. So Alpine is two-faceted. We have the Utah part, which is ongoing, that still hasn't been decided, and there's still an appeal. So Alpine, is it going to happen in 2024 in terms of it being kicked out of whatever? No, ain't going to happen in 2024. Will it happen in 2025? I don't know. In my opinion, based upon the record, I don't understand why they're still in business. But be that as it may. So we have the Utah action. Then we have the DC part. The DC part was, and again, I think it's hysterical, the term, hysterical in a non-funny way, the term they used, an expedited resolution. So they're trying to do an expedited expulsion. And we now, I think in that expedited expulsion, which happened early 2024, I believe is when it began, the appeal, and so in essence, they challenged the process of the expedited expulsion. The process began. So I think there was a couple of days of testimony, and then they pursued to block the expedited expulsion. That matter is on appeal. So if it's found that the expedited expulsion is okay, then they go back to that hearing, and they have a hearing on the expedited expulsion. Then there would be an appeal in system, and then a right to appeal in federal court. So that's if they find one way. If they find the other way, then it's kind of a different determination. If they find that you couldn't do an expedited expulsion, then there would be no further proceedings. I think then, I don't know what FINRA and the SEC would do, because they seem to be pretty inefficient in my respect. But what they probably should do is, if they can't do an expedited expulsion, then they should start a normal expulsion. And now, since we're a year after the fact, how could it be expedited? I mean, what a nonsensical name. So what's happening on that appeal? Appeal was filed, I think, the hearing, or the hearing on the appeal was March of this year. We are 7 months after that. They had some BS letter writing, but no decision. So JR mentioned, and I don't know, because I didn't see it, because I was following. We're in a new Supreme Court year. Last year we went through, some Jarkessi and Looper. We talked about some of those, and we'll talk about some of those as the Supreme Court term goes on too. But it could be that the court in DC is waiting for a decision on some other case and is not ruling. 6-7 months on this case. I don't understand it. Should have been resolved. It should have been decided already. No reason it's not decided. That to me is an inefficient court. It seemed to me they were waiting on some decision already last year to move forward, and they still haven't made a decision. So that concerns me. I don't know if they are literally going to wait for a particular decision. And again, JR and I kind of briefly discussed that. And by the way, JR, my buddy, is the king of the APA, the Administrative Procedures Act. So if you ever see him or talk to him, ask him about the APA, because that seems to be his favorite topic. But we talked about it, and we were wondering why they haven't ruled, and we're suggesting maybe there's some case in the Supreme Court now that causes them pause and whatever. All right. So we will see how that turns out, but that's Alpine. So nothing has changed on Alpine, and I don't know what the impact on Alpine will be. So now we move to Nevada. So we finally got to Nevada. Hope all of you have been to Nevada. Probably pretty warm. Hi, Busy Brands, by the way. So what's happened? We have the action was filed in Nevada, receiver was appointed. Now, the receiver, by the way, interestingly enough, sometimes, and I've had experience with receivers, but I'm not involved in that. So if you go back and listen to what I wanted to accomplish was, and this is before, long before litigation, I wanted to get rid of management and I wanted to give the company a chance to go forward and make a business, make money. And I thought that was the surefire way of resolving this. Everything after that is, whatever. It's come out, but others have control over those things. So where does that fall? So we have counsel, our counsel who got us the receiver appointed. I think they've done a great job, really. And I have contact with them, and I share a lot of things with them, and they provide me a detail. They had prior experience with Reichman. I think they've done a bang up job. They got a receiver appointed. The judge in Nevada seems to be very supportive of our position. So I have nothing but good things to say. Secondarily, there was a receiver appointed, and I think I mentioned the receiver has counsel, who I've spoken to on many occasions, and there's corporate counsel, and I'm going to reach out to them on a separate issue, and then the receiver. And I've been involved in matters with receivers before, and sometimes the receivers are getting paid a lot of money as proceedings are going on, and they're draining the estate. I've seen that before. Sometimes there's no choice because otherwise the asset would be completely wasted away. But I've seen situations in California where I thought the receiver may have been doing well. What I find interesting in our situation is the receiver is on a percentage, and a relatively small percentage. So if we don't do well in terms of recapturing assets, he does not. And he's spending a boatload of time. And I've talked about the first report. I know he's contacted many, many people. I don't know how it's going to turn out, but he's certainly active and diligent, and I'm pleased with that. And he's working on a percentage, 10%, I think is the amount, as my recollection is. So again, if we do well, in other words, if he brings a whole boatload of assets back into GTII, listen, I think that's the best thing that can happen for all of us. And, it's like in a PI case, I'm not a PI lawyer, personal injury lawyer, but in the PI case, if the PI lawyer makes a ton of money, that means you made a ton of money too. So, and that's when in a PI case, they're taking a third or 40%. I think the percentage again is 10%. So I wish him well in terms of recouping money. So the receiver put out a report, first interim report. We talked about it. My understanding is prior to the 15th, today's the 2nd. So within 2 weeks, we will have a second report. It will update us on the status of things. I know that he's been in contact with the auditors. So prior auditor was canned because they were Borgers. It was canned because they were terrible and shut down by the SEC. The new auditor was doing an audit of 22, 23 and doing the 2024. They had completed a decent amount of the work. They had some issues that were still existed. They needed comments from. I think they were about how certain expenditures, if I recall, that were in question, and they were waiting for a response. But the receiver I know is dealing with the auditor, and I know that the receiver also has on his staff a forensic accountant who can go back and, like, if things look funky in financials, could go back and figure out why they look funky and what to do. So I expect the receiver's report within 2 weeks. It'll update us where he's at and what he's doing. Now, for all you out there, this is a slow process. Unfortunately, we're going to have to be patient. It's going to take, this is law. And right now, we all know that this is trading on the expert market. The expert market, the way I think about it, the expert market is not, it's not a market. It's something. It's so the OTC can say you're on the OTC. This is just my opinion, of course, but it's nothing. I don't think, because it limits access to so many people that it's basically just sitting there like Ted Williams' head in cryo. Until that's resolved, there's not much we can do, really. And part of the process that the receiver is working on is to get the audits done, to get it to be tradable. That's why he has corporate counsel also. So again, he has counsel that represents him in the ongoing litigation in Nevada, but he also has separate corporate counsel that's dealing with, or is going to deal with, the issues that we need to get resolved so the company can trade again, and we can trade again. So the receiver is producing a report, a second report, and when I get it, I will certainly have a live, and we'll go over the content of it as we did the first one. That case is ongoing in Nevada. So just to bring you up to speed, the receiver was appointed. There's been a bunch of attempts to undo the result by the judge. There was a motion for reconsideration that was denied. There's some motions to dismiss that are set, I think, on November 13th on jurisdictional grounds that I think are going to be denied also. And then there's going to be the general litigation. Now, what's interesting is, again, the number of attorneys that have already been involved. So we knew the attorneys who represented the parties in my case and in the Nevada case. That was a law firm out of Orange County. They withdrew or filed motion to withdraw. Then there was an attorney in Nevada who came in and argued the motion for reconsideration. He was a very experienced attorney. Well, I think he was very clean. He was brought in to argue. I don't think he did a particularly bang up job, but I think he had a difficult job to do. And he's no longer in the case either. So the original attorneys are out. The next group of attorney, that attorney is out. I think I mentioned about 2 months ago, there was another attorney out of Southern California who, I think his background was, he was a former prosecutor and a white collar criminal attorney. White collar criminal is like, this kind of stuff. And prosecutor means he was prosecuting cases. And he showed up out of the blue, dealt with Nevada counsel. I don't know if he's still involved, but that was an interesting choice in specialty of counsel, because that would suggest somebody had some concerns about what was going on. So somebody's asking me how long it's tradable. I can't give you an answer. I will give you an answer when I know. It's not going to be tradable until those issues are resolved. That means the audit has to be completed, and then the process to get it uplisted has to be completed. If anybody tells you how long that will be, they're not being truthful, because we don't know. Do I expect it to be a long time, like 10 years? No, I don't. Do I expect it to be less than a year? That's my expectation without any facts. Do I expect it to be under 6 months? I hope so. Do I expect it to be under a month? No. So kind of that's the way I think about it. And I know it sucks, but that's the way it is. And that's why we had to intervene. If you recall, before the receiver was in there and before we kind of had a chance to take over company, the company got downlisted the second time. It was not tradable. We were done. In my opinion, we were done at that point in time. So the process of getting it tradable again, that the receiver is trying, and there's no guarantees of that, but he's working his darndest to get that done. And so I can't answer that question, but I will keep you apprised. And when the audits are completed, and when the movement in terms of getting it tradable again happens, I will let you know. And in the meantime, and prior, maybe within the next couple of weeks, I hope to speak to the corporate counsel and get you a little better time frame on what they think. Again, I was told about the corporate counsel, I think Friday, or I had a conversation Friday, but I will speak to them. And again, I will ask, and I'll communicate that, so maybe they have a better handle on time frame. I know it's ridiculously frustrating I follow, I watch the trading of the stock every morning. I see the number of shares traded is pretty small. So doesn't look like people are dumping, to the extent those are accurate, but it doesn't look like people are dumping because the trading volumes are very small. And it's only brokerages, I think, accredited investors. That's it, who have an opportunity to trade. I certainly do not, nor do you, nor probably does anybody who's listening here. So I know that's a frustrating thing, but it is the way it is, and I know the receiver is working on it. Now, again, that's not me working on it. That's the receiver. I just try to communicate what information I find out and I'm told, and obviously I've been actively involved, so I have a decent depth of information about that. So there's a hearing on the 13th. I expect to be denied. The receiver's report will come out prior to the 15th, which I will go back over with you. And I will keep you apprised of that. And that's kind of where we are in terms of that matter. In terms of how the cases are going to go, a lot of the action from this point forward, as opposed to the action in Nevada, will happen through the receiver, to the extent that there's additional litigation that needs to be taken. It would be by the receiver. For example, if somebody's not turning over something, assets or information, that needs to be done through the receiver, and that's what's going to happen. And obviously, I'll keep you apprised as to that. And it's moving. I think it's, to this point in time, it's gone, swimmingly. The fact that we were able to get the receiver, the fact that things have come out, and the judge seems to be, very sympathetic to our position, gets it. I think is all positive. So I'm hoping, as things go, we move on. So I went through two of the attorneys. So we had the original attorneys, they're out. Then we had the other attorney who appeared at the motion for reconsideration. He's out. Now, Kathy Griffin and Reichman have hired separate counsel in Nevada. So there's two new attorneys that are in. I don't know who's paying the legal fees. I don't know if Reichman is paying Griffin's legal fees. There was something called in some of the documents I saw, there was an indemnification agreement. Indemnification agreement means that the company will basically cover costs and expenses related to claims. Now, the company is not, but David might, or somebody else might. So that's ongoing. But it's interesting. Literally October 30th, that's their newest counsel. We'll see how long they last. I don't know. I'm not familiar with them. I think our counsel in Nevada is familiar with them, at least based upon my discussion. So we'll see if they continue on, and we'll move forward. So that's that. You'll have more information within the next 2 weeks. Hopefully, it'll be more specific. But again, it's going to take its time, and I know people are in a hurry and get annoyed and are impatient. I understand all that stuff, and I'm sympathetic to it because I'm in the same position. But being a lawyer, I understand that these wheels move slowly. And, part of it is also, listen, lawyers are making, and I'm not referring to our lawyers because our lawyers are trying to minimize the fees, in my opinion. But for a lot of firms, and I don't know if it's any of the firms representing any of the bad guys, in my opinion, as I quote, I don't know if any of those are, the actions are driven by purely economics, and as long as the case is going on, I don't know. Somebody's asking me why the stock price is going up. I just think it's purely, it's not a legitimate trading platform, in my opinion. So what it shows and why it's going up, I have no idea. In my mind, it's not tradable, so I don't even look at it in terms of what it's at. I think it's more of a joke. So why it goes up and why it goes down, it's somebody who's, since it's the market maker can really control the pricing, it's just, I think, synthetic, arbitrary pricing. And so it's irrelevant to me. The only thing that would be relevant is if at some point in time I saw trading of 50 million shares, that would be relevant. But if it's like 6, 10, 15,000 shares, I think it's irrelevant. I don't think it means anything. And so the other question is, how do the shorts? I have no idea. It just doesn't look like there's a lot of trading. So even if there are shorts, as long as the trading volumes are accurate, I don't see anybody trading at a significant volume. Like, because a lot of people believe there were, and again, I have no idea, but a lot of people believe there's a large short position in GTII. So one of two things: if there is, and there's a business that jumps off the ground, then that's good. If there isn't, then there isn't. But if there is, and the shorts were doing something in the expert market, then I'd see it in the volume, I would think. And the volume doesn't show it. So either there isn't, or like everything else, they're waiting. And maybe, if I don't know, if I was a short trading in the expert market, I don't know if you're then exposed, so that if someone has a claim, they can more easily have access to that record, to the records. If they pursue an action against the OTC, I don't know if they'd have access. So I don't know if that makes someone more vulnerable, so they wouldn't try to do that and try to do it in some black, dark pool or something like that. So I don't know the answer, but if I do, I will know. And again, I see it too. It goes up and down. I just think it's kind of BS. I don't think that's legitimate or real. So that's the answer to that one. Last but not least, I wanted to talk about, I know that there are people that okay. There are people that are interested in doing transactions with GTII. I do not represent nor promote anybody at this point in time. I haven't done any due diligence to understand any deal. I don't have any, nor am I going to, by the way, nor am I going to come to you. If I do, please hit me over the head. But I'm not going to tell you that I've gone through and looked through the deal and done the due diligence and traveled to Arkansas and looked at the equipment. I'm not going to do that. So I may tell you there's people interested, and I may, when I know, tell you who they are and what they're doing and etc. And I may expose that if I know, but I'm not promoting anything. And so to the extent, and by the way, I'm not dispromoting either, but I'm not promoting it. So to the extent that someone may have inadvertently suggested otherwise is untrue. And, to be honest, this is what I've told anybody who's approached me, because this is what the receivership counsel has told me, that until the company is cleansed, until it's tradable, there is no deal to be done. You can't do anything. You can't close a transaction like that. You can't document a transaction like that. So getting a deal done in GTII has to follow GTII being tradable, clean, audited, and in good standing. And it's not in that position. And anybody who approaches me and asks me, that's what I've told them to this point in time. And I've also encouraged them to contact the receiver directly with anything. So that's been my statement. And to the extent, again, inadvertently, people may have given a different impression, I'm correcting the record. And I'm not getting, just to be clear, I'm not getting paid by anybody. I'm not expecting to get paid by anybody. I have no contract, nothing like that. So trying to be direct about it. Try to be conservative about it also, because I have no idea. I'm not one who's going to go out and do due diligence on these deals. That's what the companies do, not me. And certainly, if maybe if it was like a legal, I guess they did. They had some legal 1-800-legal. That was something that GTI was trying to do at one point in time. Maybe, and I wasn't around or wasn't like following it, but maybe something like that. I could comment about 1-800-legal. But if you're going to buy the Baltimore Orioles, could I really tell you how to evaluate that deal? No, I could not. And so I wouldn't promote. And why would I promote? If a deal's good, it'll kind of work its way through and whatever. So just to understand that this is something I can tell you. Until GTII is in a tradable status, been uplisted, and is been audited, because part of a transaction where there's an acquisition, often one of the elements is an audit. So theoretically, you couldn't close a transaction because you'd have to still wait for those audits to be completed. And that audit is being done. So theoretically, if the audit's done and it's uplifted and it's cleansed, then GTI will be an interesting entity. And again, I've wondered about the interest people have in GTII. I wonder what's the business? Haven't really found the business, but everybody says, or at least there's a lot of people indicate that their interest is the shareholder base, like you guys, who have an interest, and a lot of people believe that because of that concentrated short position at one point in time, that there's some big upside potential. Again, I don't know about that second part. The shareholder base seems to be a very a dedicated shareholder base, so that part I understand. But I wonder also why otherwise people would be interested in GTII. It seems like a lot of people want to take the chance, or a lot of targets would like to take the chance that maybe they'll get some shares. They'll bring something to the table. They'll get shares, and those shares will take off, and they'll make substantially more than they would otherwise. So that's kind of the promotional part. But again, too early at this point in time, I think, to do anything. And if I hear at some point in time that there's actually a deal that's been accepted, or I hear something that, because the company's not going to tell me. But if I hear competent evidence of anything like that, I'll let you know. Obviously, I wouldn't want to kill any deal that I thought was good, but if I hear anything, I'll let you know. And I think that's it for today. So we talked about GTII. I mentioned, so my action's done, or will be done. The Nevada action, we're waiting for a hearing on the 13th. The second receiver's report, the actions of the receiver in pursuing collection. And by the way, that's part of what the receiver is doing. The receiver is getting it audited, cleansing all the, whatever the nonsense is, trying to get it uplisted, and then recouping assets. And again, we started off with if you look at the report, some of the assets that were recouped were the $300,000 that were sent to New York, and a $10,000 other retainer. I think there was about $400,000 that was taken back. One of the items, by the way, I should have mentioned this. I think one of the items that came up that they were waiting for an explanation, the auditor, I think this is what I recall, may not be 100% accurate, but there was about $35,000 in furniture that was expensed to meetings, and it was a bunch of furniture that was really nice furniture, but it turned out that GTII had no leased space. So I don't know what the furniture was for. We're trying to think of, are they going to furnish like outside? Like, you go outside in front of your house, and this is going to be furniture like a couch on your grass and a couple chairs, and maybe have your TV out there too. Pretty cool. But I thought that was going to be a tough one to explain. And the other item that caught my attention that I think is, and again, these not necessarily big items, but I think there might be a lot of these. And I think these are tough explanations, at least in my opinion. There was a $8,000 bracelet that I think was also referenced as a meeting expense, or something like a meeting expense. So that's if that's like a goodie bag, like you go to like a birthday party, if you have little kids and they give you some candy and a yo-yo, if you get a goodie bag, if you go to like a Halloween party, maybe that was it. There's a Halloween party. If you go, they give you a goodie bag, and inside the goodie bag is an $8,000 bracelet. I think that's cool. That's a good goodie bag. Anyway, that's something I think that the receiver is investigating. So the receiver is looking to get all the assets he can for our benefit, and I think he's diligent and is truly trying to do a good job. Although I can't vouch for him because I'm not his counsel, but I think his counsel is very competent. So We shall see. I will follow it carefully. As soon as the report comes out, I will let you know. As soon as the hearing on the motion to dismiss happens, I will let you know. As soon as my last part of my dismissal on my action is done, I will let you know. And if I have any other information, of course, I will let you know. If you have questions, comments, concerns, whatever in the meantime, what's that? Yeah, making it rain. I agree. Maybe they were actually. It would be interesting if they were making it rain in that vernacular. Yeah, it really is. It's really interesting. Unfortunately, small companies operate where principals often take advantage of small companies, but most times small companies are private. So there may be very limited people involved, maybe only a principal, only one person. So if just being realistic on a practical standpoint, if I own a company, I'm the only one, and I, rip off the company, uh, who's gonna be harmed other than maybe the IRS? But when you have a public company, and it's common that the principals take advantage of their status in private companies. Happens. So I don't, not surprising. But in a public company, you have an obligation to public investors, and you can get into a lot of scrapes by ignoring that. And I think, to me, that's what happened here. Somebody got used to a way of doing, a way of being able to conduct business, and then unexpectedly, it kind of changed. They lost their ability to control that, and now they're in a terrible position. I really do feel bad, by the way. I do feel bad for, um, it's funny because I get pissed off at them, but I also feel bad for somebody like Reichman, who at this age, he's like 80 years old. I know he's had health problems, and it's a tough way to go out. I know I get feedback about how people feel about the situation, and obviously I'm sympathetic to that, and I'm trying my best to assist to the extent I can. But otherwise, I'm still sympathetic. I see somebody ask me a question. I just kind of answered it generally. I know I did not listen to the space, and as I indicated, uh, until the company being GTII, until GTII is cleansed, tradable, uplisted, uh, and has been audited, there's no deal going to be done. That I can assure you. And again, part of it is because you can't do a deal until the audits are completed, because that's usually a term of any transaction. And to the extent, and anybody out there, anybody who has an interest in doing a deal with GTII, contact the receiver directly. Go for it. I'm not involved in that. I will not be a decision maker in any deal with GTII. I may comment once a deal is announced, because we knew that if you go look back in the history of GTII, number of transactions that they have entered into that didn't amount to anything. If you thought just a deal will generate a positive outcome, you'd be disappointed, because there was seemed like a lot of sort of transactions, but none of them amounted to anything, no revenue, no nothing. So again, you asked me about a specific, John. Hi, John. You asked me about a specific one. I did not listen to the space. I'm obviously aware of that group. But as I mentioned, I am not promoting anything, and nor is GTII in a position to do anything. And that's from the horse's mouth, the attorney for GTII. And even though we'd like to hurry up the process, it won't work. Nothing will work until GTII is corrected. And, we're all hoping for that. And again, when we starting literally before the receiver was appointed, it was not tradable. It was already in the expert market. So for all intensive purposes, in my mind, it was dead. And until we revive it, the discussion about transactions is premature. So hopefully that answers it. I appreciate the question. If anybody else has any, and again, if anybody has, though, a potential deal, they know of somebody who has a potential deal, feel free to contact the receiver directly. Really, And if you all have my email, if you don't have the receiver's email, or you want to contact the receiver's counsel and you can't find it, reach out to me and I'm happy to let you know. Thanks, John, by the way. Thanks for the comment. But if you have any questions and you want to get a hold of anybody, feel free. If you have questions for me and I can answer them, I will answer them. But I really try to be careful, because I'm not the decision maker, and there may be other people in terms of evaluating transactions that are better. So everybody. So the last question was, hey all, any good news? Hey all, good news is that we're making progress. The matter is going forward. The action against me is being dismissed, so that's good news for me, and for you. It's better you have me in a good mood than a bad mood, and things are moving forward. With the fact that we have a receiver, any good news? Yes, we got rid of management, and that was our primary goal to start off with. Management is all gone. They all were fired. September 18th. Everybody was gone. If we went back and we looked at our goals, that was our primary and first goal. So are we making progress? Yes, just have to be patient. So anybody. So to you all out there, thank you for paying attention. All be well. If you have questions, comments, please post them. And again, if you want to get a hold of the receiver's counsel, let me know. If you don't have their contact information, I'll let you know. I will speak to corporate counsel. I'm going to write myself a note because I was going to do that Friday and didn't get a chance to find out about if they have any estimates of timing. And again, I don't know if they will and what they intend to do. And again, I'll keep you apprised of the next receiver's report, which we will have in less than 2 weeks, and the motion to dismiss. For all you out there, be well, take care of yourselves, have a great weekend, and I hope you enjoyed Halloween, and we'll talk soon. Have a great day, and thanks.